Alright, buckle up, because this case is one of those rare courtroom moments where internet theory crashes headfirst into real-world consequences. Today, we're stepping inside a Michigan courtroom where a self-proclaimed sovereign citizen tries to deploy the classic, "I don't recognize your authority" argument, but there's just one problem: this isn't a traffic stop or a minor citation. This case involves serious felony charges, real financial damage, and an actual victim. Now, if you've watched these kinds of cases before, you already know how this usually goes: a lot of legal jargon, a lot of confidence, and absolutely zero legal standing. But what makes this one different is the stakes. We're talking about potential prison time, years, even decades, depending on how this plays out. Watch closely as the judge wastes no time shutting down arguments that might sound convincing on YouTube but completely fall apart under actual law. Pay attention to how the defendant reacts when faced with real consequences instead of hypothetical debates. And here's the big question I want you thinking about as we go through this: what happens when someone genuinely believes they're above the law, but the law very much disagrees? Let's get into it.
I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. Musgrove, you want to come up to the podium, please. This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger-Margosian might, oh, there he is. So, Mr. Dagger-Margosian, this is a date and time set for pre-trial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So, Mr. Dagger-Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the courts is a private for-profit.
So, Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course,
none of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction.
This right here is the critical turning point, and honestly, it's where a lot of these sovereign citizen arguments completely collapse. The judge isn't just dismissing his claims casually, she's making it crystal clear that these ideas have no legal foundation whatsoever. The all caps name, the corporate entity argument, the idea that courts are somehow private businesses, none of that holds up in any legitimate court in the United States. What's fascinating is the confidence behind these claims. You can tell the defendant genuinely believes he's uncovered some kind of loophole, but the legal system doesn't operate on belief, it operates on established law and precedent. And judges like this one have seen these arguments countless times. So here's something to think about: if someone walks into court relying entirely on internet theories instead of legal counsel, are they exercising their rights, or sabotaging their own defense? Because at this point, the judge is already signaling that this strategy is going nowhere fast.
So,
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean it is?
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger Markosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have all
But in
these.
order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case
The victim
because
would be the company. and the
you are
company-
charged.
I can't face. the
Actually,
company.
just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. That being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years.
Now the reality of the situation is finally hitting the table, and it's a lot heavier than philosophical arguments about jurisdiction. We're talking about embezzlement, allegedly tens of thousands of dollars, and an additional charge involving the use of a computer to commit that crime. That's not abstract, that's concrete, documentable, and prosecutable. And here's where the legal system draws a hard line. You can debate theory all day, but when there's a financial trail, a business claiming losses, and statutes that clearly define the crime, the court doesn't need to entertain alternative interpretations of reality. The judge even lays out the math, up to 25 years in prison if those charges stack. That's not hypothetical anymore, that's life-altering. So ask yourself this: at what point should a defendant pivot from ideology to strategy? Because continuing down this path doesn't just fail to help. It might actively make things worse.
You're charged in count two with using a computer to commit a crime. To facilitate the charge in count one, that carries a maximum penalty of up to 10 years in prison. And the way the statute's set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their
can't stand
representative
it.
can. Yes, they can. Yes,
They
they
can?
can. Yes, they
Okay.
can. So I have 189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes,
but
they
they're
can.
going-
Yes,
They're
you
going
can be
by
charged.
everything, all the
can't-
laws and statutes that you guys go by
Are
are for
legal.
corporations. They're for fixed.
Still a crime. Still a crime.
But I'm not
Still
a
a
fictitious
crime.
corporation, I'm a living person.
Yep, and that's why you're
Okay.
standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is that.
That means nothing. That's not valid. It's
Okay.
not legal.
right.
So do you want to represent yourself, or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm gonna set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr. Musk?
What we just watched is a textbook example of what happens when courtroom reality collides with unsupported legal theories. The judge laid everything out clearly: the charges, the potential penalties, and the legal framework that governs the case. At no point was there ambiguity. the defendant is facing serious felony accusations, with a possible sentence that could reach decades if convicted. We also saw a crucial legal moment, the question of representation. Choosing to represent yourself might feel empowering, but in complex criminal cases like this, it can be incredibly risky, especially when the defense strategy is built on arguments the court has already rejected outright. The bigger takeaway here is simple: the legal system operates on established law, not personal interpretation. And when there's a real victim involved, like a business alleging financial loss, the court's focus shifts entirely to evidence, accountability, and due process. Now I want to hear from you. Do you think the defendant will stick with this strategy, or eventually rely on legal counsel? And how do you think this case is going to end? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.